In this fourth part of the series, How to Get an International Divorce in Korea, I'm explaining division of property in judicial divorce proceedings. With regard to claim for division of property, Civil Act states, as I mentioned in the second part of the series, a court form of divorce by agreement does not include a property division part. Therefore, a couple who choose divorce by agreement should make a separate agreement on property division, or they should file a claim for division of property to the family court. In principle, the asset subject to be divided is joint property that was acquired by the couple during the marriage through their joint efforts, and it is unclear which of the party owns the property. As for peculiar property and joint property, Article 830 of Civil Act states, the Korean Supreme Court has held that property shall be subject to division if it was actually acquired through the couple's cooperation, even if it is in the name of one of the parties or held in trust for a third party. A couple's joint property includes all of their houses, deposits, savings, stocks and loans, and any debts or liabilities. And the debts and liabilities are deducted from that property. A key issue is what peculiar property means and how it is considered with regard to property division in the proceedings. The principle is that property owned by each party before the marriage or property acquired by either of the parties through inheritance, gift, or bequest during the marriage is not considered as marital property, and it will not be subject to division of property. However, if the other party contributed to the maintenance or increase of the peculiar property, the increase can be included in the property division. Retirement benefits and pensions that have already been received at the time of divorce may be subject to property division, and even if one of the spouses is still working at the time of the divorce and has not received the actual retirement benefits, expected retirement benefits, which are property that potentially existed at the closure of proceedings on the marriage and whose economic value can be realistically assessed, can be included in the property division, and future retirement benefits that can be expected to be received if the spouse retires at the time based on the closure of proceedings on the marriage are also subject to property division. Property is divided based on the contribution rate of each party. When deciding contribution rates, the family court considers many factors such as each party's income and the money each party invests in each asset and the length of marriage. Let's say a husband has been a single earner, his wife has been a full-time housewife during the marriage, and their marriage has continued for 20 years. Then the property will be divided on 50-50 basis, since her housework and childcare will be considered to have contributed to maintenance and increase of the property. Both parties should submit a list of his or her assets to the family court. One party may request the court to order the other party to disclose his or her assets if the other party refuses to submit the list of all of his or her assets. Usually, the assets are evaluated at the time of closure of pleadings. All the assets of each party will be added, and all the debts and liabilities of theirs will be deducted from their assets. The net assets will be divided based on the contribution rate. If the debts or liabilities are more than the assets, then the debts or liabilities will be divided. If the other party is likely to hide or sell his or her property before the judicial divorce is finalized, you can take several types of legal actions. You can seize the other party's property provisionally, you can freeze his or her bank account. However, if the other party already sells his or her property, even after the divorce suit is filed, or it is likely to be filed, you may file a lawsuit demanding a revocation of such act and recover therefrom with the family court. Also, you may press a charge against the other party for evasion of execution according to Article 327 of Criminal Act, but realistically, the possibility for the other party to be punished for the evasion of execution is low, as the elements of the crime are strictly applied. Some of my clients asked whether they could make a prenuptial agreement and it would be legally effective in the divorce proceedings in Korea. According to Korean Civil Act, an agreement on marital property between a couple shall be only effective during the marriage, so in the proceedings of divorce, it will not have any legal force. However, it can be considered when the judge decides the division of property. Today, I have explained division of marital property in judicial divorce proceedings in Korea. If you have further inquiries, please contact me via email. Thank you.